Instead of forcing the sale of the property that's been taken from you through conversion, you may wish to have the property returned. The cause of action here is called Replevin. Comes from the French word replevir, to repledge. And it's a specific relief, obviously, because you're asking for that specific property to be returned. So the process involves a complaint for trespass to Chattels, then a hearing and a argument in court and award of Replevin, and then seizure by the sheriff of the goods. There's a bond that is required. The person requesting Replevin is usually asked to provide 2 times double the value of the goods to the court before the sheriff will then go and take the goods from the defendant and deliver them to the plaintiff. This is to cover the damages compensation to the defendant if the Replevin was issued in error. So you could consider there are legal and equitable versions of Replevin. In a legal Replevin, because Replevin is actually a legal remedy, not an equitable remedy, the defendant can actually counterbond and take the property back. Sort of never-ending bonding, counterbonding, asking the sheriff to keep moving the property from one party to the other. Equitable Replevin is really an injunction ordering the defendant to give back the property. No bond or counterbond is required in an equitable Replevin. However, bonds are necessary for TROs and preliminary injunctions, but many prefer the equitable Replevin or the simple injunction to legal Replevin, as it removes the potential for counterbonding by the defendant and taking the property back again. Replevin follows an adversary hearing, otherwise it would be a violation of the due process clause.